So, okay, so that's just a mistake. Okay. All right, let's proceed, please.
Good morning. May it please the Court, my name is Marissa Pizzi, and I represent the appellant, Dr. Sophie Currier. Today, this Court has the opportunity to level the professional playing field for nursing mothers striving to balance blossoming careers in medicine with their family obligations. Your Honor, since the outset of this case in 2007, Dr. Currier has sought only one simple thing: to give nursing mothers who are physicians in training the extra break time that they need during the United States Medical Licensing Exam, known as the USMLE, to express milk for their young babies in a safe and sanitary fashion during the course of the exam. No physician in the United States, male or female, can attain a state license to practice medicine without taking and passing the USMLE, an examination that is created and administered by the appellant NBME. The NBME routinely grants extra break time to others test takers, yet in 2007, for no credible reason, the NBME refused to provide Dr. Currier with the extra break time that she needed simply to express breast milk during the second step of the USMLE.
Let me ask you this. If the NBME, if it was their policy, only to allow additional time for those who had recognized disabilities under the ADA, is this case over?
It is not,
Your
Your Honor.
client doesn't have a recognized disability, so is this case over?
It is not over, Your Honor, because that policy has a discriminatory impact on breastfeeding women.
The ADA policy.
The ADA policy. Repeat the question, Your Honor.
If the policy was the only people that got extra time to take the exam were individuals specifically suffering from a disability recognized under the ADA.
In other words, no break time for examinees at all, other than those
with disabilities recognized under the ADA. If that was, you say here, well, they didn't really adhere to, they had that policy but didn't adhere to it. Let's assuming that they adhered to that policy. What's the problem?
Well, Your Honor, that is not in fact their policy, though. Their policy is that they do provide 45 minutes of break time to all examinees.
Right.
To do as they wish.
Unless they have a disability, and then they can get other accommodations.
Other
a
accommodations.
Recognized disability, yes.
Correct. The problem is, Your Honor, that the 45 minutes of break time, and this evidence is unrebutted and unchallenged in this case, is simply not sufficient for a nursing mother of a 4-month-old infant to express breast milk at least twice during the course of the 9-hour exam, as she would be required to do, let alone attend to any of her other bodily needs.
Well, you say, I guess 2 questions. One, you say unrebutted, but the NBNAE argues that if you read your expert's testimony, it actually can be less than 45 minutes. But that isn't really what I think the question is. If what they were enforcing was pure ADA disabilities, and this one isn't, the fact that you need more than 45 minutes doesn't change that, does it?
Well, Your Honor, and perhaps I'm not understanding the question. There's the policy that you can get, or they say that you're only entitled to accommodations if you have a disability under the ADA. That is separate and distinct from their standard break time, which is they allow all examinees 45 minutes of standard break time.
Right.
If they completely eliminated the 45, is that what you're asking?
No. I think Justice Cordy is asking if you say they don't really follow just the ADA, but let's assume hypothetically that they did. Only ADA-recognized disabilities is what we give special accommodation for. Yes, everybody gets 45 minutes, but it's only ADA disabilities that we recognize, as is true of Dr. Currier with the 2 days. So we recognize that. We don't recognize anything more. Everybody agrees that breastfeeding isn't a disability under the ADA. So I think Justice Cordy's question is, given those, hypothetically, if they were only enforcing the ADA, what would be the problem?
The problem would be, Your Honor, that the policy is still discriminatory against breastfeeding women. Again, the evidence is undisputed, although you do raise the fact that they suggest that our experts say that there are minimal time savings could be had, and I think their interpretation of that testimony is rather tortured. although admittedly there may be a minimal, absolutely minimal time savings, there are much greater substantial factors that could actually increase the pumping process that they don't account for at all. But putting that aside,
So I'm sorry, I'm not trying to put words in your mouth, but what you're saying is the ADA is one thing, but this right of privacy that encompasses this is beyond that, and just recognizing the ADA doesn't accommodate.
correct.
or-
It's not only discriminatory, as we've maintained under the Massachusetts Equal Rights Act and the Massachusetts Public Accommodations Act, but it's also infringing on a fundamental, what we believe is a fundamental right in this case, in which we believe the court should find there to be a fundamental right based on both state and federal precedent. In particular, under the Massachusetts Civil Rights Act, a violation of one's constitutional rights by threats, intimidation, or coercion is a violation of the Massachusetts Civil Rights Act.
What is the coercion here?
Your Honor, the coercion that we maintain is economic coercion. This court has found that in the context of interpreting coercion within the Massachusetts Civil Rights Act, that may include economic coercion. In the case of Redgrave versus Boston Symphony Orchestra, this court made clear that the Massachusetts Civil Rights Act does not contain any state of mind prerequisite for recovery and does not require that the defendant's conduct, i.e. the coercion, be willful, but rather in determining whether the statute's coercion requirement has been satisfied, the focus is on the natural effect of the defendant's actions. Although the lower court accepted this analysis, it found that the natural effect of the NBME's actions had no such coercive effect. The lower court concluded that the NBME did not morally compel Dr. Currier not to express breast milk, but instead allowed her to do so at any time during the Step 2CK, and it attempted to facilitate the process. The problem with this conclusion, Your Honors, is that it completely ignores, again, the unrebutted evidence in this case, which is that 45 minutes of break time is simply not enough time for any nursing mother of a 4-month-old infant to both express breast milk, which in and of itself requires 60 minutes of time, let alone attend to any bodily other needs that she might have, whether it's going to the bathroom or eating and drinking. This puts a nursing mother like Dr. Currier in a really untenable position. The coercion, if you will, is that she's forced to make a choice essentially between breastfeeding, which is her right, and pursuing her career as a physician. If she takes the exam, with the standard break time, in order to pursue her medical career, she would essentially have to either abandon or significantly compromise her right to breastfeed, and as well her own health, because the test conditions do not allow for the full opportunity to express breast milk.
Can I ask you?
Go ahead.
Can I ask you? Almost all of your claims seem to turn on whether or not the NBME is a state actor, don't they?
No, the only claim that turns on state action would be the claim under the Massachusetts Declaration of Rights. The Massachusetts Civil Rights Act does not require state action, nor does the Massachusetts Equal Rights Act or the Massachusetts Public Accommodation Act. Therefore, although we do believe the NBME is a state actor in this case and that the evidence supports that they engaged in state action, even if this court were to find that there wasn't state action, there is still a violation of the other three claims we maintain on the facts of this case.
So you're claiming that all of the material facts are undisputed,
Correct, Your Honor.
and I presume that your argument is that those documents have to be viewed in the light most favorable to you as non-moving party.
Correct.
And you're not saying that any of these facts are disputed such that summary judgment's inappropriate.
That's correct, Your Honor. The parties cross-move for summary judgment, and we maintain that there
But
aren't...
you lost, so on this appeal.
That's correct. You're correct, Your Honor. And we maintain that there are no genuine issues of material in fact in dispute, and we would maintain that the lower court erred and the decision should be vacated and summary judgment entered in favor of Dr. Currier on each of the claims.
Just on the facts, so I've got this right. They offered your client 45 minutes. Didn't they expand that to 60 minutes?
They did not, Your Honor. They never offered, the one thing they've never offered her is any additional break time, and that is really what is at the heart of this case and what we view to be really outrageous. They've made several what they call them personal item exceptions, or offered several personal
They
items.
said she could bring food, she could
A
bring
whole
in
host of-
additional
extra pumps, really a whole host of things that are completely meaningless without the extra time she needs to actually pump milk. For instance, the offer to bring food and drink into the exam, however you use that food or drink, whether it's to try and eat while you're taking the exam, which is unreasonable because no other test taker has to do that, or to actually pump while you're eating, which is not recommended because it's not sanitary. I mean, either of those scenarios still doesn't change the fact that she only has 45 minutes of break time, and what she actually needs is 60 minutes just to express the milk. Again, not really accounting for any other time to do anything else. Even their offer to provide her with a separate room is wholly insufficient. I mean, by their own admission, the room itself was video monitored and enclosed in glass on 3 sides, which can hardly be considered a private room to express breast milk. But again, putting that aside doesn't change the fact that she needs 60 minutes to accomplish this
Well,
task.
let's say you win. You persuade us. Does that mean in the future that a mother who's nursing could say she's going to take a bar exam, I need extra time, I'm nursing?
Correct.
Or some other kind of evaluation or whatever it might be? I need this time, I'm entitled to it, it's my fundamental right. That's your position?
Well, we do believe it is a fundamental right. I mean, the court certainly does not have to find that to find that Sophie's rights have been violated. The fundamental right component is a element in the Civil Rights Act claim, and certainly under the Declaration of Rights, although under the Massachusetts Equal Rights Act and Massachusetts Public Rights Act, which are based on discrimination, it does not require the finding of a fundamental right. But to answer your point, to your question, we do maintain that it is a fundamental right, and certainly another examinee on a similar exam might make that claim. But again, this has to, it's a sort of case-by-case analysis. I mean, it depends on what the structure of that exam is. We're not maintaining, as the court knows, fundamental rights are not absolute, and that it's not that they can never be restricted. There has to be a balancing of interests, if you will. And in this case, what really is a critical, if not the most critical fact, is there was simply no legitimate reason for not giving her the extra break time. The only thing they point to as a reason for not giving the extra break time is the integrity of the exam. And they say this repeatedly, that it would compromise the integrity of the exam. But this is completely disingenuous because, first of all, they've already routinely grant extra break time for those, as has been alluded to, with disabilities under the ADA. So the test format can be changed. And
your client actually was given an extra day for a disability
for an
recognized
ADA
under
recognized
an ADA
disability, which was for extra test time,
Right.
and something she was entitled to under the ADA, and completely irrelevant to the issue before this court.
But she would get, this is just factual, I
Sure.
appreciate the irrelevance, but she gets 45 minutes each of those days, correct?
Correct. As part of her, essentially, she's getting double time to take the exam because of her ADHD
Right.
and dyslexia. But so the test format can be changed to allow for extra break time. They have done it. They continue to do it. It is not a matter of compromising the integrity of the exam. In addition, examinees can only take authorized break time after they have finished a block of the exam. The exam is divided into 8 one-hour blocks. So once an examinee comes back from taking a break, they cannot revisit prior sections of the exam. So there's absolutely no concern of cheating or otherwise compromising the integrity of the exam. So this reason that they've offered is completely illegitimate, and that there's simply no reason for providing her this really very minor modification that she's asking for. Additionally, Your Honors,
Just pragmatically, the case is moot. I mean, she's already taken the test and passed.
well, not moot in the legal sense, I guess I would say,
right.
because
But
the
I
lower
mean,
court
but in the
found that it was
practical
not. But
sense,
in the practical sense, she has.
I assume at the end of this, it is not an appropriate result to say go to trial, because it is, after all, moot. If there are factual disputes, I assume you want a resolution one way or the other and the case to end. Is that fair?
That's fair to say, Your Honor. We don't think that there are any genuine issues of material fact such that a trial would be necessary.
Well, you said that, but I mean, but isn't there an issue of fact as to whether they intended to discriminate?
Well, I don't think so, Your Honor. I guess I would have two responses to that. One is that intention to discriminate is not necessary under the Massachusetts
Okay.
Public Accommodation
But
Act.
it's
only
necessary, well, fair
under
enough.
the under the you're correct, under the Massachusetts Equal Rights Act.
I'm sorry, intent is only relevant under the
Massachusetts Equal Rights Act requires purposeful discrimination, but a fact which, by the way, the lower court I don't think fully appreciated, because it dismissed the Massachusetts Public Accommodation Act claim based on its analysis of the Massachusetts Equal Rights claim, which found that it was not purposeful. But so to answer your question, I don't think that the intention question is such a genuine issue of material facts such that it would require being remanded to the lower court. Essential facts are not in dispute, and we would maintain that whether that rises to the level of purposeful discrimination is a determination that the court can make on the facts of the case.
Could I ask one more question? Sure. On the public accommodations and the Massachusetts Equal Rights Act, which, as you say, require discrimination as their base, correct? Back to Justice Cordy's original question. On those two claims, if the NBME absolutely followed the ADA disabilities, no exceptions, nothing else, and they apply that equally, men, women, whatever, wouldn't that be the end of those claims?
Again, Your Honor, I don't think so, because we're dealing with a gender-specific condition here. Breastfeeding is obviously something that only pertains to women. And so men are not while men are not getting any break time either, they don't have a condition that women have that requires, it's an absolute medical need for a lactating woman to express breast milk on a regular basis. I mean, that's, I think, what distinguishes breastfeeding from some other maybe temporary conditions that the NBME has suggested. I mean, this is a physical need on the part of a woman to regularly pump breast milk, and it involves a time-consuming process. It's not something that can be done in 5 or 10 minutes.
All right, thank you, counsel.
Thank you, Your Honors.
May it please the Court, I'm Joe Savage. I represent the National Board of Medical Examiners. With me at counsel table is Suzanne Williams from the General Counsel's Office of the National Board of Medical Examiners.
Mr. Savage, why, putting aside all this statutory constitutional arguments, why does this interfere with the integrity of the exam?
This is a computerized, timed test. And for the results to be comparable and relied upon, the testing conditions have to be comparable and relied upon. So when we give the test, every state in the country knows that it was given under these circumstances, and everyone took it under identical circumstances.
Well, that's not true,
Except when
though.
Congress said you have to change something to equalize the circumstances for the disabled. There's no one disabled here. And so we, by law, are required to make that one exception to our otherwise entirely uniform approach. The first sentence from appellant today was that they're here to level the playing field. That is, in fact, untrue. If you follow their logic, the one thing that will happen as a result of their argument is an unleveling of the playing field. If every applicant for the test who has a gender-related physical condition that requires additional time is allowed a modification of the test, you will have a disparity. For example, if a woman comes in and says, I need additional time because I have cancer treatments for my thyroid, and a man taking the same test says, I need additional time because I am having cancer treatments for my prostate, we would be required under their logic to give the man additional time and not the woman. And every single other gender-related condition.
But cancer does not respect gender, but breastfeeding does. I mean,
Well,
to my knowledge, there are no men who have this particular issue. I mean, why is it not the case that there is a subclass of women Well, that basically all men have 45 minutes to do whatever they want during the course of the 8 hours, but there is a subclass of women who have to use that 45 minutes at best to breastfeed and don't have a moment to leave to go to the bathroom or to eat outside of the exam. Isn't that a gender-based distinction?
No, first of all, the distinction is all of you who come to us with temporary physical conditions get treated identically. Some of your temporary physical conditions may be gender-related. For example, breastfeeding or enlarged prostate. Those are treated just like every other physical challenge that someone who's taking the test has. It's not about gender. We don't have a breastfeeding policy. We have a ADA-mandated requirement that certain people be given accommodations, and then a uniform policy for men and women that there's no change to the testing format.
And does the ADA itself, one of the examples was some temporary physical disability. Does the ADA require that you give on a temporary basis accommodation?
It does, Your Honor. What the ADA says is, quote, the question of whether a temporary impairment is a disability must be resolved on a case-by-case basis, taking into consideration both the duration or expected duration of the impairment and the extent to which it actually limits a major life activity of the affected individual. That's exactly what we do. If you qualify, temporary or chronic, for having a major life impairment, we are required by law to give you an appropriate accommodation to take the test. We treat 100% of the rest of the test takers identically.
So the enlarged prostate, is that a temporary impairment?
It would depend what the expert said. If it, for example, caused the need for repeated urinary issues or whatever, such that the person couldn't sit or something, and the expert evidence from the doctors was that that is in fact disruptive of a major life activity, then yes.
And expressing the need to express milk is not a temporary impairment under that view?
That's what the plaintiff has told us, is that it's not a disability.
But you could have.
I think there could be extraordinary circumstances.
No. I'm saying that your organization could, notwithstanding what a breastfeeding, lactating mother wants to call it, your organization could categorize this in the same way.
We would never falsely call breastfeeding a disability. It's not a disability.
A temporary impairment
of a major life activity that affects access to the test. There's no test taking is not a major life activity.
Well, wait a minute. You just said that you would accommodate somebody with a prostate condition under certain conditions. So that's not test taking either is or is not a major life activity.
No. The test is, does this impair a major life activity? And if the mere impairment is of your ability to take a test, then you're not disabled under the ADA. So what we would have to have from an expert on the prostate example is that it impairs a major life activity.
So it wouldn't be every prostate person.
Correct. Excuse me?
It would not be every person that has prostate cancer.
No.
It would be some special added thing, which could also be true of a lactating mother. There could be some special added thing that turns it into a disability, is what you're saying.
I have no idea on the prostate what the experts would say. I'm saying that there are gender-related conditions where people would say, I need more time, that are not disabilities. And so the prostate condition is not a disability, but it's a gender-related condition where the guy says, I need more time. If they're right, we have to give more time to everybody with gender-related conditions. We don't give time to anybody with any conditions unless...
Well, we could read the record differently.
I'm sorry.
I said we could read the record differently about the uniformity of your policy.
I absolutely do not believe you can, Your Honor. I think the record is absolutely crystal clear. There is one comment by one consultant that said this is not technically under the ADA. The consultant's wrong. The 3 times that are in the record where we gave people additional time for temporary conditions were to 3 women. So it's not like we have a thing about discriminating against women. We gave 3 women who had impairments of major life activities on the undisputed record of the doctors that examined them. So there's just no question.
How do you categorize the need, though, every 2 to 3 hours to express milk? How do you characterize that as something that is not an impediment?
Oh, no, it's obviously a physical challenge that some of the other test takers won't have. Other test takers may have.
And all males will not have?
No males will have it. There's no question about that. But there may be males in the room that have other conditions that are even more demanding. We don't know. We don't accommodate any of, I mean, it's a bright line rule, so we don't make any relative judgments amongst people who are not disabled as to who'd be best served by more time.
Okay, but lactating mothers are an equally bright line. I mean, you wouldn't, if you were to say that for lactating mothers, we do this, that would not open the door to everything. It would be for lactating mothers. So why is that why would that be a problem?
What you'd have to do that, I mean, just to analytically look at it, you can't do it as a gender thing, then. It can't be under public accommodations or the Mass Equal Rights Amendment. You'd have to find that uniquely lactation is a fundamental right. That would put you under the Declaration of Rights, and then you'd have to find we're a state actor. And we are not a state actor. Under your teaching in Phillips, for us to be a state actor, we have to displace the Board of Medical Examiners, and they'd be shocked to, I mean, the Board of Registration of Medicine, and they'd be shocked to hear that we've displaced them.
You could also find economic coercion and go under the Mass Civil Rights Act. I mean, it's the same, the right is the same.
Yes.
It's just a question of what door you go in to recognize it.
Right, and then the coercion issue is someone facing a choice, someone who's being morally compelled to forego a right.
May I ask, just hypothetically, if you had a person who, let's say they were a diabetic and they needed to take insulin shots every couple of hours, would you consider that a temporary impairment of a major life activity? They file an application to you?
I don't know. It depends what their doctor said. If their doctor said they cannot go about their daily life because this is in the way, I mean, that's a very technical expert opinion that I'm completely unable to give you the answer on. I mean,
But the process would be, with my hypothetical, that they would apply, they'd submit medical information.
just as Ms. Currier did for her ADD and whatnot, and we are open to all of those, and we have a panel of experts, and they present their own expert information, and we try to evaluate those fairly so that we obey the law. And there's nothing in the record here, for example, that our policy of only ADD, so we deny everybody else.
Only ADA.
Excuse me, only ADA, exactly, thank you. And I'm with the MBME, and there's a lot of problems here. But that our ADA only policy, the universe of other people who want more time, there is not a scrap of evidence in the record that that's more women than men. There's no reason to believe that's the case, in fact. We could, in fact, have more men asking for more time than women. There's nothing here that supports the claim of disparate impact.
No, but it's, I mean, the case that is referred to is Mass Electric. I mean, pregnancy versus, I mean, pregnancy and lactating mothers are sort of in the same.
There is no case stronger for our point than Mass Electric. In Mass Electric, the company gave men insurance for everything, and it gave women insurance for only some things, and left out pregnancy. And this court said, got to treat them the same. Here, we deny everybody equally. We give men and women the same standard.
But the consequence of that is that a subclass of women have 45 minutes less to do what the class of men generally can do.
No, the subclasses of men have less time too. The guy who has irritable bowel syndrome, whoever that day has a problem.
But it's not a, I mean, isn't the difference, though, there is a guy who has irritable bowel syndrome, or a woman, and there is a class or subclass of women. Every lactating mother is presumably going to be in this situation.
Well, but then now we get to the gender-related physical conditions that men have, and we're into the prostate subclass, and they're all going to have that same condition. So It's not like there's
No,
one,
not
unless you
necessarily.
uniquely find.
Not necessarily. That would be depending, I thought you said on what the doctor said as to that specific
No.
individual's condition.
No.
You know, if that particular gentleman had a prostate condition that required him to go frequently to the bathroom, that would be one thing. But you could have somebody who had a prostate condition where he did not have. That would be a very person-specific thing, unlike, I think there's probably only one way to express milk.
But the frequency of expression might
Exactly.
differ.
And the experts are varied on that, and there's a dispute in this case as to how long it takes. But no matter how thin we slice it, it's never going to be that this is just a woman problem.
But I don't get that. I mean, you speak about the prostate. If you refer to it as a urinary problem, that's not unique to men. I mean, there are women who need to urinate more often, too. So I'm not aware of any other problem that would be a subclass of men. I mean, I don't know of any parallel that you can identify, which, unless you want to take a body part. Obviously, if you take a body part, it's unique to men. But if you take a problem or a functional issue, such as the need to express milk, that is unique to women. Urinating is not unique.
No, but an enlarged prostate is unique to men, and the various consequences that the doctors say for that are unique to men. The only way to deal with this, that it doesn't go into other groups, is to go down the route that we were discussing earlier, that it's a fundamental right being abridged by a state actor, which we're not, or it's a civil right that we're coercing by providing a choice. The gender one, just analytically, it seems to me, doesn't work.
Does your analysis mean that in your view, sort of defeats the MCAD's use of the public accommodations because it's gender related and for all the reasons you've said, it doesn't?
And the MCAD, in all due respect to their recently filed brief, made up stuff in the record. I mean, there is no evidence in this record that our policy of turning down all the applications from men and women that are not disabled disparately impacts women. Indeed, it may well be that we turn down many more from men. They just said there's a disparate impact. That doesn't make it so. Thank you.
Thank you, sir.